folks, we apologize. Welcome back. Spoon TV with me, Sylvester Chidople. Apologize for the breaking due to internet.
2025. Hence, by established legal principles and procedure, the refiled amended bill of information is the one for the court's consideration. The crux of the amended bill of information are set forth in counts 1.2 and 1.3 therefore, and for the purpose of expediency and relevancy, we quote verbatim the said counts as follows. Quote 1.2. In the ruling, the court held that whether a simple majority, a sitting or a lower number, in both cases, a presiding officer defined in Article 49 of the Constitution as the Speaker, and in his or her absence, the Deputy Speaker must preside. And in the final judgment, Your Honors held that any sittings or actions by members of the legislature not in conformity with the intent of Articles 33 and 49 of the Constitution are ultra vires. Hence, members of the House of Representatives are to conduct themselves accordingly. The clerk of this court is hereby ordered to inform the parties, and it is hereby so ordered. Count 1.3, still quoting the amended bill of information. In the ruling, Your Honors held and determined that the sittings, decisions, and actions that the self-styled majority bloc previously took were authorized, i.e., unauthorized, and therefore illegal. This included the unconstitutional removal of Speaker Koffa as Speaker and the purported election of Representative Coon as Speaker. In the court's final judgment, Your Honors ordered the members to conduct themselves in compliance with both the quorum provisions of Article 33 as well as Article 49, which required the presence of the Speaker as the constitutional presiding officer on the court. The informants further cite in count 2.1 of the amended bill of information the actions which they believed amount to violation of the Supreme Court's mandate. Also quote the alleged violations as contained in count 2.1 as follows to wit. 2.1, quote, the deliberate and intentional violations and direct contravention of the court's ruling and final judgment. Representatives Spoon and Fonati and other members of the self-styled majority bloc have continued to convene and hold unauthorized hearings, including budget hearings, all of which were declared authorized and invalid in Your Honor's ruling and final judgment to wit. A. Voting upon and passing into law the fiscal year 2025 budget document without authorization, recklessly endangering the full credit of the Republic of Liberia by purporting to legislate the primary fiscal instrument that drives the nation's economy and spending power when they knew or should have known they did not have the authority to do so. B. Authorizing the withholding of salaries and legitimate benefits of certain members. C. Authorizing the payment and disbursement to certain of its members for their personal benefits, financial resources belonging to the House of Representatives, or financial instruments belonging to non-members of the majority bloc. D. Invading the premises of the office of the Speaker of the House by the use of force without authorization or court order and refusing to allow the Speaker of the House of Representatives to conduct business by seizing the instruments of governance of the House using force, and E, attempting to recall from their lawful assignment the members who are representatives to ECOWAS when they knew or should have known they had no legal right to do so, unquote. On March 14, 2025, the respondents filed a 36-count returns to the amended Bill of Information, denying therein any violation of the Supreme Court's opinion and judgment of December 6, 2024. In their 36-count returns, the respondents first proceeded to extensively refer to numerous portions contained in an opinion by the Attorney General, alluding to the December 6, 2024 opinion of the Supreme Court. These are found in Count 1 and 9. Counts 1, 9, and 15, and 9 to 15, in fact, of the returns. This court notes that the referenced opinion by the Attorney General is not before the court and therefore will not burden his opinion by delving on same. It is common knowledge, though, that one of the duties of the Attorney General as set forth in the new executive law is to furnish opinions as to legal matters and to render services requiring legal skills to the President and other agencies of the executive branch of the government. Howbeit, it must be noted that the said opinion of the Attorney General do not change or affect the rulings and or opinions of the Supreme Court or subordinate courts, and any opinion given in that regard is of no relevance to the opinion and judgment. 18, count 19, count 20, count 22, count 29, and count up to from 33 up to the grade 4. And this is violated the order of mandate of your order's opinion and judgment of December 6, 2024 in the Constitution that indicates 2, that the amended Bill of Information is meritless, unfounded, and frivolous. 3, the prayer of said amended Bill of Information is denied. And 4, that the entire Bill of Information is dismissed with costs and informants and appropriate sanctions imposed on court. Having reviewed the records, especially actions allegedly perpetrated by the respondents, we must now determine whether the adverbials asserted by the informants are within the province of our Bill of Information. We firstly reaffirm our holdings and decision in the December 6, 2024 opinion, caption in reconstitutionality, etc., as well as the accompanying judgment excerpt of which we quote below. 1. That is court's interpretation of Article 23 of the Constitution 1986 is that whether a simple majority is sitting or a lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in case of an absence, the Deputy Speaker. 2. That in the event where the Speaker is presiding over a minority, the Constitution is devoid of the mechanism for how the minority is to compel attendance of a majority who choose not to attend session. And the legislature has promulgated no enabling statute or standing rules setting forth the process for compelling absentee members to attend sessions as envisioned under Article 33 of the Constitution. 3, that was the wherefore portion of our 2024 ruling. Wherefore, any view of the foregoing, any sittings or actions by members of the legislature not in conformity with the intent of Articles 33 and 49 of the Constitution are ultra-vires. Hence, members of the House of Representatives are to conduct themselves accordingly, unquote. It is obvious that notwithstanding this first declaration in repetition as to what the law is and what adherence thereto is required of the then petitioners, now informers, as well as the respondents thereto, who are also the respondents herein. Each party has ascribed different interpretation to this first opinion and judgment. These differing views are the bedrock of this amended law of information, as the respondents have prayed. As the respondents.
Folks, stay with us. Spoon TV in Sylvester Chiroplay, coming to you live from the Temple of Justice. We have the.
As the respondents have prayed in category of this return to the information that this report must be definitive and exact in its disposition of the amended bill of information, so that this ruling of December 6, 2024 will not be susceptible to more than one interpretation, since the informants using their interpretation of the court's opinion of December 6, 2024 has caused continuous disruptions and interruptions at the House of Representatives, with the sole aim of making the House of Representatives dysfunctional. This view by the respondents therefore requires the court not only to revert to the opinion from which these proceedings emanate, but to provide clarity and remove all cloud of uncertainties, if any, as to this court's opinion and judgment in the petition, to obviate any future misinterpretation thereof. In executing this task, we are reminded, as we stated supra in this opinion, that the Supreme Court, in making a determination of this amended bill of information, is not only confronted with the letter of the law, but also the weight of public trust and the mandatory constitutional obligation to uphold the sanctity of our jurisprudence as an independent court that holds together the fabric of our democracy through adherence to the rule of law. This court, speaking in the case in the constitutionality of the Act of 1914, espoused thus, quote, "The court stands between order and anarchy, facing the latter, anarchy, with a stern repressive frown, and extending aid and encouragement to the former, that is order. In the same light, we are duty bound to speak and interpret the law according to the intent of the framers, remaining oblivious to sentiments." Reverting to the in-read petition that was filed by Councillor Fonati J. Koffa in his capacity as Speaker of the House of Representatives, the petitioner sought a declaration from this court that the actions of certain members of the House of Representatives were unconstitutional. Specifically, the Speaker argued that those actions violated Articles 20A, 33, and 49 of the 1986 Constitution, which addressed due process, quorum, the designation of the Speaker as the presiding officer,